welcome. Sorry for the delay. I had a squirrel in my kitchen. Yes. It bit a hole through the screen and jumped in the dog food. So I had a pit bull and a squirrel running after each other, and I'm with a broom and a softball bat like this. Swear. Just happened. Can't say. That's the story. Done. That's what happened. What's up, people? How we doing? OMG, we have Simpson and Bryant on a roll today. I got a little Florida. But let's begin the show with my man, Judge Bronlick, and then we'll roll. We got main events all over the place. What's up? Oh, it's a Sean Wexler sighting. What's up? Daylight, KCC, Michelle, John Hart. How we doing, people? All right, let's roll.
Does not have audio on?
Hello, can you hear me?
Yes.
Yeah.
Can you hear the Stevenson?
Yes,
sir.
Court is now in session. September Stevenson versus Dakota Stevenson.
For the record, this matter is before
What's
the
up,
court
Michelle?
for continued pre-trial conference,
My
as well as the motion of Attorney Scott Mussing to withdraw as the attorney of record for the defendant, Dakota Stevenson. This hearing is being conducted via Zoom. Present is
whatever.
the plaintiff, September Stevenson, and her attorney, Teresa Reiser, as well as Dakota Stevenson and his attorney, Scott Mussing. Good morning, everyone.
Good morning, Your Honor. Just a slight correction on the motion. I filed it. I've not served it. I wanted to get through the mediation and see how that went before I talked to Dakota about whether or not that needed to be done. So I don't have that motion pending.
Okay, there was no stuff for hearing today, but it was not served very well. We can proceed then. The parties appeared before the court back, I think, in February 3rd. They're going to mediate with Michael Jones. Did that mediation ever take place?
It did, Your Honor.
Okay.
Unfortunately, we were unable to reach a resolution at the mediation.
Okay. At the initial pretrial conference, I think that's before Miss Reiser was involved. The court was informed the only issues were custody.
They had audio issues the entire time. Do you hear the echoing? And now it sounds like someone playing with plastic pops. What's going on? And isn't September Stevenson just lovely? She's so happy to be there.
Parenting time. This is a pretty short-term marriage. Is that still the only remaining issues?
I believe there's some debt that goes in with that. I don't know that the debt is the huge problem with the major issues, the custody of
I mean, we really didn't get to talk on any of that. Me and September have talked on it since the mediation, so.
That's not my understanding, so.
Not your understanding what? That we've talked?
That you, right.
I mean, it's on the court. It's
My
on the
understanding
Hold on, Mr. Stevenson. Let
Yes,
the
sir.
attorneys speak, please.
Yep.
My understanding is there's still not an agreement.
No,
Okay.
I never said there was an agreement. I said that we've been talking about it. But there was nothing at
Let's
that
go ahead.
mediation. I got to talk for 20 minutes at the mediation. If that, she got 3 hours. So we haven't got nothing to discuss. We haven't even got to discuss it. I haven't been able to discuss it with her.
Okay. Do you want to, Mr. Mussa and Mr. Reiser, do you want to talk with someone from the front of the court? They might be more adept at parenting time issues than Mr. Jones, especially who's not allowing both parties to speak freely.
Yeah.
honestly, Your Honor.
Hold on, Mr. Stevenson.
Yes, sir.
Mr. Stevenson, I'm talking with the attorneys, please.
Yes, sir.
Yeah, honestly, we've met with a friend of the court already, and we got almost nowhere with that. I think we met a second time, and we didn't get anywhere. And then we had Mr. Jones come in, and we spent a good 3 hours with him going back and forth, and there's just no movement on either side.
Okay.
Guys.
The court notes that there was a custody parenting time order entered in December. Obviously, no one's petitioned the court to modify that, so.
There was a ton of squirrel left all over the place. That's why I was late. Because then she started munching on squirrel. The the droppings all over.
Things
How
seem
do we
to be
do
working
that? 'Cause
well.
I don't know how to do
should-
that, sir.
Hold on.
I'm trying to do that.
Please mute. Can you mute Mr. Stevenson? All right. There was an order entered back in December of 2022 that had set forth a temporary order for custody parenting time. There's been no motion to modify that. There's not been any problems, at least that's been brought to the court's attention. So it seems like we have something in place. Ms. Reiser,
There is an order.
date, Mr. Bussin? Do you need
Yeah,
a
there
hearing
is
date?
I'm sorry, Your Honor.
Do you want to hear a trial date?
No one could hear.
Yes.
Yes.
A 4-year marriage and you want a trial date. I think it's the first time in the 10 years I've been at the bench that someone with a 4-year marriage wanted a trial date.
I agree, Your Honor. We're not moving at all. I was
Okay.
very impressed with the mediator, and there's no movement at all.
All right. Do we need a half day or do we need a full day?
Who's he raising his hand?
I'd almost think it's a full day, Teresa. I don't know.
I'd love to say
concluded.
half. I'd love to say
Has
half,
this-
and
Has
I
discovery concluded?
I
Yes.
think we have some outstanding discovery requests.
Of course, not going to set a trial date until you complete discovery. Don't waste the court's time.
I understand.
So let's take the proofs. If no one has the objection, I'll set another pretrial conference with an order that the parties complete discovery by that date. Any objection to that?
No objections.
All right. The court will reserve outstanding issues.
Objection.
We can unmute Mr. Stevenson.
I didn't know that I could file a motion to get what's it called. I've been called CPS. I've had a lot of issues during this time, and I just didn't
Mr.
realize that I
Stevenson?
could file a motion to get the custody turn. I've called my attorney a million times.
Mr. Stevenson, hold on. When you get done here, you call your attorney, Mr. Muslim. Talk to them on the phone about those.
He's not
things.
helped me. At this point, he hasn't helped me. I've been calling this, and I've been trying to file different things, so I don't know what's going on. I literally don't know. I got to talk to the mediator for less than 10 minutes. It was a 3-hour meeting. I had to pay $480 for. I got less than 10 minutes to talk to the mediator, sir.
Your Honor, I'd also ask the court to give me if the court has a hearing date for the motion as well.
Right, Mr. Stevenson, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes,
I
sir.
do.
Thank you. All right, Ms. Rice, we can be with Ms. Stevenson to establish jurisdiction and that she's not currently pregnant. I believe it was simply, can't remember, two children born to the marriage, please.
Your Honor, give me one sec. Ms. Stevenson, is it true that you filed a complaint for divorce in this manner?
Yes.
And did you live in the state of Michigan for 180 days immediately before filing that complaint?
Yes.
And did you live in Monroe County for at least 10 days immediately before filing that complaint?
Yes.
And you have 2 children, correct? With
Yes,
Mr.
ma'am.
Stevenson? Yes. And are you currently pregnant?
No.
Do you want me to continue on, Your Honor, or?
No, that's sufficient, Ms. Reiser. Mr. Bustin, do you have any questions, Ms. Stevenson?
No, Your Honor, I don't.
Okay, perhaps you can simply have your client identify himself and ask him whether he heard the testimony of his wife and whether or not the testimony is true and accurate. I think that's all we need from Mr. Stevenson, please.
Understood. Mr. Stevenson,
Yes, sir.
did you hear the testimony of September Stevenson as it relates
Yes,
to
sir.
the time she lived in the county and the state and whether or not she's currently pregnant?
Yes, sir.
Okay. And you understand that testimony and you believe it to be true and accurate at this point in time?
Well, yeah.
Okay. Thank you, Your Honor.
Oh, yeah.
All right, based upon the testimony that's been presented, as well as the complaint filed in this case, court finds that jurisdiction has been established and that there has been a breakdown in the marriage relationship to the extent that the object of matrimony have been destroyed. There appears to be no reasonable chance of reconciliation. At this point in time, the court will reserve all outstanding issues, schedule this matter for a final pretrial conference. How much time do you need in which to complete discovery, Mr. Musson, Ms. Reiser?
Probably at least 30 days.
Okay.
Could you repeat that, Your Honor? I couldn't hear. You broke up in the middle of like halfway through that.
The court is reserving all issues, and the court asks
Is this a time served live stream with all these audio problems? Anyone?
the attorneys how long they need to complete discovery. And Mr. Musson said 30 days.
Okay, thank you.
Ms. Reiser, would you agree 30 days should be sufficient?
Yes. Yes, Your Honor.
Okay, so they both available on June 8th at 8:30 for a final pretrial.
Yes, sir.
Yes, Your Honor.
I've got a settlement conference
Okay.
at 8:30. That's in Oakland County.
All right, they're just setting up their dates. All right, let's roll. We got Judge Mercer. Let's do a little Judge Mercer. Let's do it to it, people. Here we go. Mommy and son are going at it.
Appearance accused of one count of aggravated assault with a firearm and one count of obstruction without violence. It's resisting and without violence charge. Mr. Pravat, there is probable cause certainly for the resisting without violence. The ag assault, I am not 100% sure. I texted the attorneys this morning and told them I'd like to hear from them on their thoughts. So we're going to start with the state. Ms. Jeffcoat?
Your Honor, I think it would be a close call on the full aggravated assault. I think there is probable cause for attempt to commit aggravated assault since he was making attempts to get into the gun safe. And that would still be a third-degree felony given the offense level and the score sheet level. It would still be a third-degree felony in this situation.
Hang on. Somebody just came to the courtroom. Are you here on this case, ma'am?
He done that 2 or 3 weeks ago. He was drinking. He just needs help with his drink. That's all he needs.
What's up, Toby?
Brett said he ain't never done nothing with no gun or no nothing. Or,
He did what 2 or 3 weeks ago? This was yesterday is what the complaint says.
they did their gun safe about 2 or 3 weeks ago or more. He didn't have no firearm. He was just drinking and got out of control. And I told him to quit threatening.
Okay. Come on up, ma'am, because what you're saying does not match the complaint I've got in front of me. We need to clear it out, figure it out. So what I'm gonna do is place you under oath, ma'am, get your name and try to get some additional information. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth so help you God?
Thanks, buddy.
So help me God.
Okay, you can put your hand down, ma'am, and you're Jan Pravat?
Yes.
And you're his mother?
Yes.
Arthur's mother. Ms. Pravat, the complaint I've got says the officer responded yesterday at 12:45 and that saying that you had threatened to kill her, he had threatened to kill you with a firearm, and then it goes into him trying to get into the gun safe.
No, no.
That's not what
He
happened.
tried to get into the gun safe 3 or 4 weeks ago. See, I've told him to quit drinking, but he won't listen. I said, you keep threatening when you're drinking. If he's not drinking, he's unwilling kind. He'll even remember that he's threatening. I said, you can't do that. You keep threatening. What if you do something when you're drunk and you ain't gonna remember it? Please quit drinking.
Quit
Ma'am,
drinking.
Did he make the statement, if I had a gun, I would shoot you in the head and kill you?
Oof.
Not exactly.
Okay, it's in
Right.
quotes in here. Author stated, quote, if I had a gun, I would shoot you in the head and kill you. The officer saying you told him those words. Did you or not?
Well, he did say he'd shoot me if he had.
So was that yesterday?
verbal.
Was that yesterday?
That was yesterday. He said that, but
Okay.
he didn't. break
Then
the
it
gun
goes on,
safe.
well, ma'am, I'm just trying to figure out what's happened because what you're saying now doesn't match what the officer says you told him. Okay, so I'm just trying to work through this. So that was yesterday. Then it goes on to say that Jan stated the author has been attempting to break open her gun safe and she believes if he continues, he will be successful and kill her. Okay, so that was, you were talking about a prior incident.
Yeah, that was prior.
He was not trying to get in the gun safe yesterday.
No.
What else happened yesterday then? Because that's what he's been arrested for.
He just said that he was drunk. So drunk, you don't even, just like this. And he gets mad. He found out he had diabetes. He's blind. His eyes are getting worse. And
He's got the diabetes.
he don't have no life. He's miserable. I just kill myself. I'm just tired. I don't even want to live.
Yep.
And then yesterday he was just acting crazy. By the time the cops got there, he was sitting there in a chair when they come.
Arthur also threatened to kill Jan with a stick. Did that happen?
He ain't had no stick.
Okay. I'm not asking if you had a stick. I'm saying that he threatened to kill you with a stick.
No.
You tell the officer it happened?
I said that if I didn't know, I don't remember saying nothing about the stick.
Were you drinking?
No,
Are you wanting no contact with him?
No, I want to contact with him.
You want him to be able to come home.
Yeah.
So what are you wanting us to do today?
I want him to get help for his drinking. If he wasn't drinking, he wouldn't be there where he's at now. He's got to have some help with his drinking.
Let me see if the state or defense have any additional questions for Ms. Pravat. Ms. Shefcoat?
I don't have any questions for her related to this, Your Honor.
And Mr. McDaniel?
I don't have any questions for him.
Okay. The only other question I have, ma'am, is you said he's blind?
Thank you.
He's blind in one eye, and his other eye's getting worse. He just found out he has had diabetes, and he's going through so much stuff. I think he just wants to drink himself to death.
Does he have, but the gun safe, he can see well enough to see the gun safe?
Yeah, he can see it. He couldn't get into
Tell me about this gun safe. Is it like a locked gun safe? Like
it's a Canon, it's a Canon gun safe, big gun safe.
One that's big, thick, with like a fire resistant gun safe?
Yeah, fire resistant.
Okay.
Good
And has it got a key?
No,
Ma'am, I'm asking you specific questions for a reason. Does it have a key or some kind of
sir.
combination?
It's got a combination.
Does he know the combination?
No.
So he can't get in it?
No.
Okay. All right. Thank you for coming, ma'am. You can have a seat back in the audience.
What's up,
Mr. McDaniel, anything else?
Your Honor, Ms. Jeffcoat knows more about these issues than I do, but attempted aggravated assault, it just don't rhyme together. You got to have, certain elements for aggravated assault.
There's no probable cause. There's no probable cause for that charge. He can't get in the gun safe. He doesn't have the code. It's not reasonable threat of imminent harm. There's no probable cause for ag assault. There is probable cause for obstruction without violence. There is probable cause also for misdemeanor assault. So I'm going to find probable cause for the lesser included charge of misdemeanor assault and resisting an officer without violence. I'm going to let Mr. Pravat pick between a conditional release and a bond. Mr. Pravat wants him home. Mr. Pravat, you can choose between the conditional release and bond. It's entirely up to you. Either way, there's going to be a condition of no alcohol because alcohol was allegedly involved in this incident. So if you want to post a bond, you can post a bond of $2,500 on each of these two because essentially I'm finding probable cause on misdemeanors. If you'd rather accept the conditional release, I'm going to grant you the conditional release. Mr. Pravat, either way, you have a condition that you cannot possess nor consume alcohol because alcohol was part of what's happened. I am not going to put what allegedly happened. I'm not going to put a condition of no contact between your mother. You can go home, but you can possess or consume alcohol. If there's documented reports of you possessing or consuming alcohol, enough evidence, then that can violate your conditional release or bond, and you can go to jail with no bond. Ma'am, if he possesses or consumes alcohol on bond or release, then that violates the condition of it. You would contact law enforcement. If they verify that he's done that, they can put him in jail. If they call me, I'll tell them to put him in jail. That'll be my instructions. So, Mr. Pravat, when you get through talking with Mr. McDaniel, we'll see if you have any questions about that option.
This was a good one.
I guess conditional release. Your Honor, he's going to ask for a conditional release.
Mr. Pravat, I'm going to grant you a conditional release. You're going to be brought to the courthouse in just a little while. Sir, they'll instruct you on the terms of the release. The conditional release officer will, that is. He'll answer any questions you have about it, and then you'll be free to leave. Ma'am, are you going to be able to pick him up? Be about a half hour. He'll be downstairs in the probation office, which is inside the county judge's office. Okay? Your mother's going to pick you up, Mr. Pravat. I'm sorry you're having these health issues, but alcohol is not helping any, it appears, based upon what I've heard this morning. Mr. Pravat, do you have any questions? Do you have any questions, Mr. Pravat?
No, sir.
All right, sir. We'll see you at the courthouse. Ma'am, he'll be downstairs in about a half hour. Okay? Thank you for coming.
The guy probably is a
Jasmine,
sweetheart. Probably good to his mother. He just goes crazy when he's drunk because he's got a lot of pent-up aggression. That's all. All right.
Mr. Dickinson.
What is going on here? Oh, boy.
Thank you, sir. We are on the record this afternoon for the 28th Circuit Court for Missaukee County. We're calling the case of the people of the state of Michigan versus Kyle Dwayne Dickinson. This is case number 23-3385 FH. Appearances from counsel, please.
Again, I'm David and on behalf of the people.
Thank you, Your Honor. Stephanie Ruffalo for the Wexford Missaukee Public Defender's Office on behalf of Mr. Dickinson, who appears with us via Zoom from Jackson. He is currently incarcerated. Thank you.
Mr. Dickinson, again, are you able to see and hear us this afternoon?
Yes, I am, Your Honor.
Thank you very much, Mr. Dickinson. We're here today for looks like a final pretrial conference maybe, and I've been told that the parties have reached an agreement. Mr. Denham.
Thank you, Your Honor. It's my understanding that the defendant will be accepting the people's offer, which is to plead to count one, resisting, obstructing, and in exchange, the people would be dismissing at the time of sentencing the habitual third notice.
Thank you. Ms. Ruffalo?
Yes, Your Honor, that is a correct recitation of the plea agreement.
Mr. Dickinson, have you heard what the attorneys have described to me as the terms of the pretrial agreement?
Yes, I have.
And is that how you wish to resolve today's case, sir?
Yes, I did. Yes, Your Honor.
Please raise your right hand. You swear or affirm the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. Mr. Dickinson, I understand that you are in confinement. Do you have any objection to taking today's plea via Zoom?
No, I do not.
Thank you. Mr. Dickinson, you are charged via a felony information, which is a charging document, with count one, assault, resist, obstruct a police officer, which is a felony punishable by up to 2 years and or $2,000. I'm told you're going to plead guilty to that offense. Now, there's also what's called a sentencing enhancement. In this instance, it's called a habitual offender third. That would have the impact of increasing that felony punishment from 2 years to 4 and from $2,000 to $4,000. However, I'm told that again, if you plead guilty to that count one and the plea is accepted by this court, the prosecutor will dismiss the request to treat you as a third habitual felony offender. Is that what you understand so far?
Yes, Your Honor.
By entering a plea of guilty, you'll not have a trial of any kind. If your plea is accepted, you will be given up certain rights that you would otherwise have in a trial. Now, that includes the right to be tried by a jury, the right to be tried without a jury, if you chose and the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have a silence used against you, and the right to testify if you chose to testify. Do you understand those rights, Mr. Dickinson?
Yes, I do.
And are you willing to give those rights up today, sir?
Yes.
Additionally, any appeal from the conviction and sentence pursuant to the plea will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. If the plea is accepted, you will also be given up the claim that the plea was a result of any promises, threats, or inducements that were not disclosed to the court on the record, or the plea was not of your own free choice, or that, I'm sorry, that's it. Are you under this plea of your own free choice, Mr. Dickinson?
Yes, I am.
Have there been any other promises, threats, or inducements?
No, Your Honor.
Now, Ms. Ruffalo has probably discussed with you the Michigan sentencing guidelines, applied her experience and given you an idea as to what you might be sentenced to. My question for you is, has she or anyone promised you exactly what the sentence would be from this court?
No, Your Honor.
Knowing all that, do you still wish to enter the plea of guilty as we discussed earlier?
Yes, I do.
As to count one, assault, resist, obstruct a police officer, how do you plead?
Guilty.
Before the court can accept your guilty plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to October 16, 2022, in Riverside Township here in Missaukee County, what happened? Were you stopped by law enforcement? Tell me a little bit about that.
A state cop stopped us, and I was unwilling to move my arm from the door.
Tell me about, were you in the vehicle?
I was in the vehicle, and he was trying to open the door, and I would not budge my arm.
All right. So were you the driver or passenger?
Passenger.
And did the officer try to open the door?
Yes, he did.
And did you then have your arm kind of hanging out the door to help keep it from being opened?
When he reached in to try to open the door lock, I wouldn't budge my arm. if that makes sense.
So in other words, he couldn't complete his duty to get you to step out of the vehicle. Is that right?
Yes.
All right, thank you. Mr. Denhout, do you believe the defendant provided a factual basis as to count one?
I do, Your Honor.
Hold on, Mr. Dickinson, did you happen to know the trooper's name?
No, I do not.
Ms. Ruffalo, would you agree that or stipulate on behalf of Mr. Dickinson that it was Trooper Brock or
Brent Benavides.
Brent
yes, Your Honor.
Benavides?
Yes.
For some reason I thought it was Brock, but it was probably Brent.
Yes.
All right. And you believe that the defendant has provided a factual basis as to count one?
Yes, I do, Your Honor.
And Mr. Denhout, you aware of any other promises, threats, inducements?
No, Your Honor.
Ms. Ruffalo?
No, Your Honor.
Mr. Denhout, do you believe the court is in compliance with mission for 6.302?
I do, Your Honor.
Ms. Ruffalo?
Yes, Your Honor.
The court agrees and finds the defendant's plea today is made freely, can only involuntarily, therefore the defendant is found guilty of count one. The request to treat the defendant and sentence him as a third habitual offender will be dismissed at the time of sentencing. Mr. Dickinson, as you might be aware, a pre-sentence investigation report must now be prepared. That report will be prepared by an agent of the Michigan Department of Corrections.
All right, here we go.
Mr. Jessup.
Simpson had case after case after case after case of goodies. I couldn't even pluck. It was just one after another. So, Mr. Jessup, been here in his courtroom before. Oh boy, this is great.
Could you please unmute and state your name for the record? You're muted, sir.
These are,
So I think it was last year.
they are.
75 and 15.
Mr. Jessup, you're muted. You'll have to unmute.
Unmuted, okay. Can
There
you guys
you
hear
go.
me?
Yes. Can you state your name?
Are you serious? You guys can see me, you can hear me now.
I can hear you. Yes. Can you state your name?
Yes, my name is Timothy. My last name is Jessup, Jessop.
Thank you. Your Honor, Mr. Jessup was unable to complete the intake with probation. He was in custody in Florida. I would like to ask if we could get the re-referral fee waived, given that he is homeless and was in custody. He has plans to contact them and get that intake completed. He's also discussed with me those other cases that he has on warrant status, and we're going to be working on getting new court dates for those so that he can get those.
Well, I'm going to arraign, I'll be able to give him court dates on the one and I will arraign him on the other felony.
Okay.
So we'll take care of that. I will adjourn the matters. I'm not going to waive the fee in this case. I understand he may have been in possession, but or may have been in custody, but this case has been going on for quite a while. We've had to issue numerous bench warrants. This could have been taken care of a lot earlier before he went into custody.
Oh, yes.
Down in Florida. So I'm not waiving that. I'll refer for probation for a PSI. He's to pay a $75 re-referral fee on each of these cases. That's $150. He's to pay that today. I'll adjourn his sentencings in these matters to June 14, 2023, 9 a.m. on both cases. And then Mr. Jessup,
I'm trying to.
you are before the court
This is like
on,
a rare, okay. Hello?
on, yes, can you hear me?
Yeah, I can hear you. I can hear you. Yes.
All right, on one case, and that being case, the case ending in 231-260. In that case, sir, you have, well, that one indicates he was in custody of Florida. You are before the court on a charge of retail fraud in the second degree on that case. That
Can you repeat that? I'm sorry.
That is, pardon?
Can you repeat what you just said?
Yes,
that
I have a complaint that alleges the offense of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration. $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken is greater than $2,000. Do you understand what you're charged with and the nature of that charge?
Can I hear the state's evidence? Because I'm trying, I'll be honest with you, this case has been going on for so long and the communication's been a dire situation. And not to mention, I ended up having to stay in jail for an extra day because he had forgotten to sign.
Mr. Jessup, Mr. Jessup,
Yeah.
this is a new case that the judge is trying to address.
Oh, yeah, okay. I have no idea what he's talking about. So, I'm trying to hear you over the traffic here.
Well, then you need to get yourself someplace that you can hear the court.
I was. Remember that one day I was at a car wash
Mr.
and
Jessup,
it was right,
Mr. Jessup,
yeah, side, and you left when you said,
Okay, so here's what I'm going to do, Miss Reed. I'm going to pass these matters because if he keeps it up, I'm just going to leave the warrants outstanding on. And then I will recall it. He is to get himself to a quiet place. He is to get himself to a quiet place that he can hear the court so that he may be arraigned on this misdemeanor and on his felony.
understood.
I am passing it. I have no idea what he's talking about. He told Simpson, I have no idea what he's talking about. Remember, I was at the car wash.
Court calls the case of the people versus Shatisha Lee.
He's laughing.
Silvana Reed, Assistant Public Defender, with and on behalf of Miss Lee. Miss Lee, could you please unmute and state your name for the record?
Ready? One right after.
Thank you. Your Honor, today is the day.
Is that her?
Jessup's still on. Look. He's still on.
Yes.
Okay,
Hi.
she's the fire tablet. Got it. Okay.
I couldn't figure out how to put my name in.
It's okay. We got you. Okay.
Today is the date and time for sentencing. In this matter, we have reviewed the PSI report. We have no additions, deletions, or corrections, and we ask that probation's recommendation be adopted.
Ms. Lee, is there anything you'd like to tell the court before I impose sentence?
That you're all appreciated. That's it.
All right. Thank you. It's the sentence of the court. Place you on prosecutor's deferred sentence for a period of 4 months. You're to pay $555 fines and court costs, $120 probation oversight fees. When can you pay that?
I not sure at all. I would need a payment plan.
All right. You don't have anything at this time?
Sorry to say, I do not have anything at this time.
Payment plan as directed by probation.
Thank you.
There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. Now, you cannot go to any Meijer store in the state of Michigan. You are to submit fingerprints to the court, or you are to submit your fingerprints, actually not to the court, with proof to probation. I'll set a review hearing September 13th, 2023, 9 a.m. I'll order 365 days in jail. That is suspended. Thank you.
Thank you. Have a great day.
You too. Court calls the case, People versus Crystal Lewis.
Silvana Reed, Assistant Public Defender, with and on behalf of Ms. Lewis. Ms. Lewis, could you please unmute and state your name for the record?
She is not checked in. Crystal Lewis.
Warrant.
Where are my stickers?
Sticker. Warrant.
There you go.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Darling. What's up, Philly?
Court calls case of People versus Jack Lyons.
Silvana Reed, Assistant.
Random testing as directed by probation. You are to complete an anger management class as directed by probation. There's to be no contact with Kenneth Hood directly or indirectly.
Okay. All right. So, right here, is an unbelievable case. I just dropped a video on it. I gotta play it live. Miss, it's Sophia right there. It's a case where she reached in and a mom with the kids in the car. Let's go.
Okay, go ahead.
Hi.
What's your name?
My name is Karma.
Okay. What would you like the court to know?
Yes. Good morning, everybody. Just like to thank the courts for giving me this opportunity to make a statement. This incident happened to me over almost 3.5 years ago, and I've been patiently waiting and glad it's coming to an end. When this incident happened, I'm not going to water it down. Miss Fimby and her counterpart decided to pull up behind me and my 2 young daughters in Starbucks drive-through line and approach my car, yelling threatening words at me. And as I ignored it, Miss Fimby decided to get out of her car and run up to my window as I'm trying to order, and thought it was okay to punch me in my face through my window car. Or my car window, I'm sorry. And at that moment, I thought I was dreaming. And as I put my car in park and wanting to get out my car, my daughters, both of my daughters were in the car, and they begged me with frightening tears not to get out the car. And I didn't. At that point, I don't know if my daughters maybe saved my life. But I felt very violated, humiliated after being punched in my face in front of my daughters. And my ego was surely broken and bruised. And in that moment, I struggled, and I still struggle with what I did versus what I really wanted to do. But I keep telling myself I did the right thing. Although there was no financial effect upon my family, it has definitely left an emotional impact upon us. For me, it has tormented me with the thoughts of wanting to obtain a CPL license. Never have I ever felt a need to carry or purchase a firearm. But since this incident, I am slowly going through an emotional process of obtaining a CPL. But I continuously ride this roller coaster on if I should or not. My daughters who witnessed this crime was frightened, traumatized, and distraught. And my one daughter's whose idea was it to go to Starbucks that day blames herself for what happened. Prior to this crime, a place of business we visited so frequently, we have not been able to go back to this place since the incident. What Ms. Fimby did was an unprovoked act of violence, and there was little to no actions of remorse based on her actions. For example, Ms. Fimby assaulted me. She and her counterpart decided to get back in their car and run away from the scene. After I pressed charges, Ms. Fimby never showed up to her preliminary hearing, which was issued a bench warrant. Now it's been over 3.5 years, and Ms. Fimby's bench warrant caught up with her, and she did not want to take an offer and wanted to go to trial. It goes to trial, and I show up to testify, but now Ms. Fimby pleads no contest. Where is the remorse? Your Honor, what needs to be identified as an acceptable and responsible path to deter such behavior. And I'm asking for some sort of jail time to be sentenced, whether it's 2 months, 1 week, or even 3 days, with the continuum of what probation is asking for, along with some sort of therapy. A lesson just needs to be learned here. And Ms. Fimby, what I feel, needs to be punched in her face, and maybe not as recklessly, physically, and barbarically as she punched me in my face in front of my 2 daughters. That was, again, not provoked. She needs something
brutal
to learn her lesson. Thank you.
Miss, what do you think jail time would serve in this case?
I'm sorry, were you talking to me?
Yes, ma'am.
Oh, I just feel like when the thing happened, she wasn't even arrested. When it happened, she was let go. I feel 2 weeks to 2 months, something. That's what I feel.
Yeah, but how do you see anything being gained from that?
Well, I think it gives a person the time to think about their actions. I think she has not been able to given a time to think about her actions. So to really critically think about what her behavior was.
Okay. Counsel, anything you want to say before I impose sentence?
I would just state that I understand where Ms. Stewart is coming from in terms of how this impacted her. Ms. Fenby has thought about her actions. This court case has been going on for at least a little while, but there has, as stated, been about 3.5 years since the event occurred. Ms. Fenby has taken time to consider that, especially given her involvement with the court. She has not had any other criminal history outside of this case. She is employed and she has been compliant with all court orders. I believe that probation's recommendation will allow her to be under court supervision and continue considering her actions and how those impacted others. I think that the recommendation from probation is reflective of the stability that Ms. Fenby has in her life, and also balances her having to serve some sort of punishment, as it be, through probation, which would be appropriate given, like I said, the offense and her lack of criminal history in this matter.
Fenby, anything you'd like to tell the court before I impose sentence?
No, Your Honor, other than that, I am very sorry and very remorseful in this case, and I apologize for taking the court's time. Thank you.
No, that's what I'm here for. Can I ask why you did this?
Because sorry, I feel very panicked. I felt that when the car was put in reverse, I interpreted that as being put in reverse to hit my partner that was outside of the car. And I didn't know what to do to defuse the situation. I was very scared. So I did do what I did, but I've never done it.
Why does that sound so fake? I'm sorry.
Thing like that in my life, and it wasn't intended to hurt. It was just intended to stop the situation. Although, and now I realize it was not the right.
Intended to stop the situation. I can't.
Thing to do.
Yeah, but the car wasn't moving when you took the swing, was it?
The reverse lights were on, and I panicked.
But was it moving?
No, I thought it was going in reverse, though. It was very close to us, and he was between the two cars.
Ma'am, in the time that all of that happened, had that been Miss Stewart's objective, she could have gone into reverse and caused great damage, right?
Yes, I thought that's what was happening. I thought that's what was gonna happen.
Hold on a second.
I'm sorry.
But while you're thinking about that happening, you had to exit a vehicle and get yourself up next to her vehicle and then take the swing, right?
Yes, Your Honor.
That's a lot of time, relatively speaking, isn't it?
It didn't feel like it at the time, but yes.
Well, it's a lot of time, given what you were trying to prevent, right? All of that could have occurred within the time frame that you got out, walked up to her vehicle and hit her, correct?
Yes.
So tell me what makes me believe that you won't do this again. This is, I mean, as I read this, it's one of the most troubling things for me because it's a lot like road rage that just is occurring, sometimes inexplicably. So tell me what will assure the court that you're not going to do this again.
I have never in my life been involved with any kind of violent interaction, and what I did not come from a place of anger or wanting to punish someone, but just from a place of fear. But I know now I've learned my lesson, and I will never do anything like this again, nor have I done it before.
Simpson does not.
This is very uncharacteristic of me. I am not a violent person. I'm not an angry person.
Ms. Stewart, how old were your daughters?
They were 7 and 9 at the time.
Okay.
Michelle. I don't buy it for a second. It's a cry off.
See if she can
Ms. Fenby?
Mute, lady.
Ms. Fenby,
Yes.
when you hear Ms. Stewart not so much talk about herself, but about the effects it had on her daughter, what comes to your mind?
I feel horrible. My heart breaks, and I'm so sorry for the impact that this made. I never wanted anything like this to happen, and I am so sorry.
Mr. Jessup's still there.
But what do you think about when you hear a mother talk about what her daughters are thinking?
I feel very bad. I feel very remorseful, and it honestly breaks my heart. I would never want to have that impact on anyone, especially children, and I am so sorry.
All right. Ms. Stewart, let me tell you this. A couple of things. I don't believe that imposing jail at this point is the thing to do. Because I don't think, as I listen to you, I don't think that that's necessarily what you really want to have happen. Sounds to me, and maybe I'm wrong, and feel free to correct me, but I think what you care about more than anything in the world is not even the punch, not even any of that, but your daughters think and what they think now going forth in the world. I think that's primary to you in everything. As I'm listening to you, I'm trying to decipher what you're telling me, and that's what I'm getting from it. Okay, and I'll just say, as a parent, I hear you. Right, it's tough enough out there without stuff that's happening. But also, I have to say that as I read the report and everything, I have to commend you. Because what you could have done is to step from that vehicle, cause a confrontation that could have gone anywhere. And a lot of bad things could happen. right? But what you did is you got your family out of the way, went down and you reported. Quite frankly, I don't think there's a greater lesson that you could have imposed upon your daughter or given your daughters as to, in certain events, how to handle that type of situation. Because you could have taught them something very different. And so, like I said, I have to say, when I look at this, I commend you. I've been sitting here a long time and I see these incidents, something like this, and they just escalate into things that we can't even imagine that it even started the way that it did, and then it turns into whatever. Okay. But I also don't think that jail time is it.
I would like to
Because
say,
I don't.
I did
Go
explain.
ahead.
I did explain to my daughters what. So me, of my request is a request from my daughters, and then me explaining what the possibility of what the sentencing would be, and I did talk to them about what probation was offering. And as my daughters, who is now 14 and 12, from the words of their mouths, they said, "That's it. That's all she would get."
No, I understand.
So I'm just
Yeah.
saying, and so yes, I am here fighting for what my daughters would want, or what the words they said to me. So I know how things are, but in their head and what they interpret and what they see, and what they saw and what they think what they feel the law or what bad people do, or think what's supposed to do, I think that they won't get it. They won't get it. They won't understand.
They may. They may. I think that kids are a whole lot.
As they get older, over time. But I think, I just think as two young African American girls who see a Caucasian woman assault a Black woman, they see what they are seeing in this world.
Uh-oh.
And they said, "That's it. Is that it?" So I'm here because I am fighting for them. I am fighting for them. What they think should
I
happen.
understand that. But ma'am, let me just tell you this.
Yeah.
And since you broke it down and brought it up, I was raised by a Black woman. I understand, and I understand how I'd feel if that was my mother being hit. But I also understand what our sense of justice is and what really has to happen. And quite frankly, despite what they may want, as parents raising kids in this world, we don't teach them about what the ultimate thing may be, but we teach them about what the right thing is. And sometimes what we have to do, despite all of the other things that are going on out there in the world, we have to have them understand what may be true justice. Just because something else is happening to somebody else or something is happening in a particular way, that doesn't mean doing X on this end is the right thing. Because I think that way, quite frankly, that's how our kids get in a lot of trouble. And so it's going to take moms like you, like my mom, like all of those moms out there to teach kids that there's a different way, despite what their reaction may be. So I understand what they say. I get it, because I know how I'd feel if it was my mom that was hit. Okay? I don't know that it would have turned out that way. I could see me and my brother coming out of that back seat. I don't know. All right? That's if we could beat my sisters out of there. So I get it. But I think they need to be shown that there's also a better way. And that certain things aren't going to happen the way that they want. I will just say also, in a moment of levity, having raised a daughter and also having my niece, that while I appreciate their thought process in it, I don't know that I'm going to be taking sentencing advice from 14-year-olds. I just, they have their own way of thinking about the world. I mean, I appreciate their view, but no, we let them run the world. We're all going to be in trouble. But anyway, all right. So here's what I'm going to do, though. And Ms. Polera, I'm going to increase the probationary term. So I'm going to order one other thing. Instead of the 12 months probation, I'm going to send it be placed 24 months probation. She has to pay the $555 fines and court costs. Her probationary fees will likewise concomitantly go up to $720 probation oversight fees. There is to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as directed by probation. You are to complete an anger management class within 60 days. I will order that you're to continue your current mental health services at Packard Health, follow all recommended aftercare, including therapy and medication protocol. There is to be no contact with Karma Stewart or her family, directly or indirectly. Do you understand that, ma'am?
Yes, Your Honor.
There's to be no assaultive, threatening, intimidating behavior on your part. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will order 93 days in jail. I will suspend that jail. I'm going to add a term other than the increase in probationary time and the like. And that is, well, let me put it this way. You know, it's easy to use words, Miss Envy. And it's easy to say those words, remorse. It's easy to say those words after it's all over, I'm sorry. But one always has to wonder whether or not you mean it. I realize when people get before me, they say that all the time. And I have to sort out whether or not they really mean it. So, Ms. Polera, and you know, the other thing, Ms. Benry, I'll just say this. You're telling me that you understand it and that you feel bad about it.
Bad doesn't really cover it.
You sound, okay, well, you sound like an articulate person to me. So I'm going to reserve the court's right and jurisdiction to impose jail term during this probationary term. But here's what you're going to do. You're going to write 2 letters of apology. The first letter of apology is going to be to Miss Stewart. And I'm going to see whether or not you truly are remorseful. That letter of apology is to be given to probation. I don't want you to have any contact with Miss Stewart. And so that's the first letter.
Okay.
You understand that?
I do. I wrote it down, yes.
And I will be, Ms. Wimby, so that you understand, I'll be reviewing those letters. So I'm going to be the one to see if there's remorse there. So you're going to write that to Ms. Stewart. But then the other thing you're going to do, and in a separate letter, because I think that there are separate issues that if you were really hearing what Ms. Stewart said and not just giving lip service to her, and you don't need their names, I don't want you to add their names, they're minors. You're going to write a letter of apology to the daughters. And I would suggest to you that in that letter, that you deal and grapple, maybe to the extent you understand, with what Ms. Stewart said about how it would feel to see that happen to your mother. Because see, I don't consider myself a violent person, but I know what me and my siblings would have done. I can just tell you. Because that would have been just a mess at Starbucks. If it were my family. And that's why I give Miss Stewart all the credit in the world. But I want to see those, and then I will make a determination as to whether or not I will impose any jail time on the 93 that I've suspended. Everybody understand that?
I so appreciate that. Thank you.
Thank you, folks. Those letters will be due to the court within 30 days, Ms. Blair. Okay.
Yes, I noted it, Your Honor.
Now I posted this one. I dropped this, and I got a lot of the same comments that I'm seeing here. Natalie, you're correct. People were saying he dropped the ball on this one. What do we think? Did he drop the ball on this one or what? I don't know. He's not perfect. I don't know. All right. Let's see what the poll says. Let's go to the... Listen, I'm playing both of them. You guys know I don't sell you short. Ever. I'm just saying which one's the main event. All right. So we're closing the poll. All right. Lucy special first. This was a goodie from Judge Ricky. Hope you guys enjoy it. Thank you, Miss Rose, for the daily content, darling. You are the best. James, thank you, sir. James Lambada, frequent flyer here. Always in the comments, too. All right, here we go. Let's do it. Lucy special up first. Why is it not coming through? Hope we can get the Lucy special. There we go. We good, Lucy. Thank you, Lucy, again. This is a goodie.
Hello, Lamont Prince. Case number 2022 CR 112. Jill Gillette appears as Greenwood County Attorney. Chris Pate as Defense Counsel. Defendant Prince appearing at a remote access Zoom location located at the Greenwood County Courthouse in Eureka, Kansas. This matter comes before the court at this time for sentencing. The court's notes indicate that the matter came before the court last on March 15 of 2023. Defendant pled no contest to count 2. Other counts were dismissed pursuant to plea agreement. A pre-sentence report was ordered and sentencing set for today. The crime of conviction, according to the face sheet on the pre-sentence report, is conspiracy to unlawfully obtain and distribute a prescription-only drug, a severity level 2.
Doesn't this go, party rock is in the house tonight? Doesn't LMFAO.
10 non-drug, non-person felony. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and is there any objection by the state to the criminal history?
No, Your Honor.
And I presume there wouldn't be any objection by the defense, Mr. Pate?
There is no criminal history, so we have no objection, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Ms. Gillette, are you aware of any legal reason why sentence should not be pronounced in the Prince case here this afternoon?
No, Your Honor.
Mr. Pate, are you aware of any such legal reason?
No, Your Honor.
Mr. Prince, are you aware of a legal reason or any other good reason as to why the court should not proceed further with your sentencing this afternoon?
No, Your Honor.
All right, court will proceed further then. Counsel, I'm not aware that there's been any motion for a departure sentence or any other sentencing related motion that needs to be taken up. Are there any motions to be pursued by the state, Ms. Gillette?
No, Your Honor.
By the defense, Mr. Pate?
No, Your Honor.
Are there any victims and members of a victim's family present who desire to address the court in relation to this sentencing? Court finds no such persons present, so at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Prince, beginning with Jill Gillette on behalf of the Greenwood County Attorney's Office.
Your Honor, this is a single count complaint and it's presumptive probation. Essentially, this is Mr. Prince's first soiree into being in trouble. He, I believe, got caught up with the wrong people. I reviewed the criminal history of his co-defendant, and to me, he was the mastermind of the case. He had charges of the same stuff all over, and Mr. Prince has no criminal history. He has taken responsibility for both his actions here and Elk County.
How do you figure that? He entered a no contest plea here, so he didn't take any responsibility in the truest sense. He didn't admit anything. He just said that in pursuant to a plea agreement, I will accept conviction for one of these charges. So
right. He's also pleading at the same time in Elk County and resolving his cases globally. He's also turned himself in on the Elk County case because there was a warrant outstanding for him and taking care of his warrant there. So he's worked out a global resolution. In this matter, he is presumptive probation, and the recommended sentence is 6 months standard in the standard box, and we would recommend a 6-month underlying sentence. This is his first case ever, and it is a felony, so he would have the DNA requirement that falls under the KDOC. He would have up to 20% good time credit, and he would be recommended to be on 12 months probation and have, if he served any time, 12 months post-release. There is a KBI lab in this case. The prescription was tested. They all go to the lab to confirm what's in the bottle is correct as to what's in the bottle. And so he also had KBI lab in Elk County as well, because they're two separate charged cases. And we would ask the court to inquire pursuant to Robinson as to any attorney's fees. He would have court costs, KBI lab, $200 DNA database fee, $120 correctional supervision fee. I see that he is recommended to court services and not community corrections. There is a booking fingerprint fee in this case. And again, that BIDS application fee is requested and have the court inquire of the defendant. We'd ask for the standard terms of conditions of probation. I believe Mr. Prince lives across the Kansas line in Kansas City, Missouri area. I don't have an objection if he has his probation transferred after he makes his initial appearances here in Kansas. He would have to have the interstate compact approved. We have, and he did come across the state line to turn himself in with Elk County. So we'd ask for the standard conditions in which he would have for probation. Ask he pay a minimum fee every month by the last business day of each month. And this case will count on his criminal history in Elk County. So that case will come up for sentencing later. But like I said, there's a global resolution here.
Does he still have a court date set in Elk County on June the 5th?
He does, Your Honor.
All right.
They were committed on the same day. They went to Elk County first and then came to Greenwood County.
Very well. Thank you, Ms. Gillette. Mr. Pate, your recommendations regarding an appropriate sentence?
Your Honor, this is a presumptive probation case and criminal history score. We'd ask the court follow the presumption, place Mr. Prince on court services probation for 12 months. We would ask for a 5-month underlying sentence with 20% good time and 12 months post-release if a prison sentence was ever imposed. It looks like there is 1 day jail credit in this case. From what I know and reviewing everything and talking with Mr. Prince, I agree with Ms. Gillette. I think this is a case of being caught up with the wrong people. I understand we're all responsible for our own actions, and we've all got to take responsibility for the consequences of those actions. However, in my opinion, it's a lot easier to behave correctly when you're surrounding yourself around good people. Mr. Prince did not plead guilty, but he did accept conviction, waived prelim, and waived trial on this case, saving resources of the court and the state. So he did accept conviction on this. And it looks like probably a similar deal down in Elk County, although I'm not directly involved on this case.
I'm trying to get you directly onto it now. It's just the process. I can't get a hold of them like too easily. Something goes wrong every time, but I'm trying my hardest right now, Chris.
Okay, well, they'll sort that out on the 5th. So in any event, Your Honor, we'd ask the court grant probation 12 months with a 5-month underlying prison sentence.
Firing squad.
How much are your fees in the representation of this client, Mr. Pate?
I'll double check real quick here.
Why does Mr. Pate look like Ricky put him in timeout? I think he's standing up against the wall. You all right, Pate?
Prior to today, they were approximately $720.
Thank you, Mr. Pate. At this time, the court will address the defendant, Andre Prince, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present. Mr. Prince?
Your Honor, I would greatly, deeply appreciate if you did give the 12 months probation. I just had a newborn daughter, and I would do anything in the world to take care of her, to do anything to stay here with her. I'd do anything, show up to all court sessions, all everything. I don't want to run from you guys. I don't want any trouble with you guys. I never have and never will ever again. I apologize for your time, for everything. I apologize. And that's it.
All right, Mr. Prince. I'm reading part of the pre-sentence report in this case, Mr. Prince.
Grab your membership.
And this was your version of this offense.
Grab it.
I want to read it into the record. I was easily
the
influenced by some friends to go into a pharmacy and pick up some medicine for their uncle, which turned out to be a fake prescription that I didn't know of at the time. When we got pulled over, they lied and said it was mine.
When we got pulled over,
What was this uncle's name, Mr. Prince?
I don't remember the name, Your Honor.
Okay, so let me get this right, Mr. Prince. For somebody who's supposedly taking responsibility, you're from Lee Summit, Missouri, which is close to Kansas City. You find yourself in a rural southeast Kansas County of Greenwood, and some friends ask you to go into a rural Kansas pharmacy and pick up some medicine, not for themselves, and not for you certainly, but for their uncle, whose name you don't know. And this turns out to be a fake prescription that you claim now that you didn't know of at the time, yet you accepted conviction for conspiracy involved in this. And then when they got pulled over, they put it on you. They lied and they said it was yours. And despite all of this, you don't fight it. You accept conviction for the conspiracy charge to obtain a prescription-only drug, which in this case was identified
I'm talking with my lawyer.
Cody, if I recall.
Yeah. While talking with my lawyer, the best option was to not waste your guys' resources
You guys
and your money. I would also be looking at time in jail if I did do that and I was convicted still. And one thing I don't want to do is lose time away from my daughter. I really had no intentions in doing anything wrong here.
You just were in the wrong place in Kansas at the wrong time. Is that what you're telling me?
I was with the wrong people at the wrong time.
What were you doing down here anyway?
I was told we were going to go hang with some of our other friends from high school that moved out here and family.
He should have just came clean.
You responded.
I was
committed.
I was called that morning. I was called that morning.
Let me read this. You were being nice and influenced to do the wrong thing without knowing. I was being gullible, which I presume you mean gullible.
Gullible? Yes, sir. Yes, sir. Yes, sir.
He was being Golby. I would love how he spelled that. In the chat, how did he spell gullible? Go.
So this crime was committed because you were being nice. All right, anything else you want to say, Mr. Prince?
Party Rock is in the house tonight.
And the dumbness of this case, I apologize. You will never see me out here in trouble again. I'll do anything to make it up to you guys.
Except maybe show up for your felony sentencing on time.
Yes, sir. Yes, sir. I apologize. We took a wrong turn, and I'll take the blame for it. That's my fault. I should have typed in the full address correctly instead of putting Greenwood Courthouse. I apologize, sir. I take that.
He probably spelled Greenwood wrong. That's why it got lost.
That's my fault.
Well, just note, Mr. Prince, that the court set this sentencing in the afternoon to accommodate that you would have all morning to get here.
Yes, sir.
From the Kansas City, Missouri area. I didn't want to rush it first thing in the morning.
I
And yet
apologize.
I said it in the afternoon and you're late anyway, wasting the valuable time of how many professionals on this meeting?
Gumblewood.
I sincerely apologize to all of you guys, Chris, Jill, Jessica, and you, Judge, and Mandy. Miss Mandy, I apologize to all of you for wasting your time. And even though I was supposed to be here at 1:15, I came late. I apologize.
Purple nurple.
Very well, the court will pronounce sentencing in this case at this time. Court hereby establishes count 2 as the base sentence in this case for the offense of conspiracy to unlawfully obtain and distribute a prescription-only drug, a severity level 10, non-drug, non-person felony, which the defendant has a criminal history score of I, thus placing him in grid box 10I. Court hereby imposes the aggravated term of 7 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court does find that in grid box 10I, that the defendant would be presumptive probation under Kansas law. There's been no motion for a departure sentence before this court, nor is there an application of a special rule. Therefore, the court will grant the defendant probation to be supervised by a court services department for a period of 12 months, at least initially. Conditions of that probation will include the following: reporting to an officer as directed, observing all laws. Defendant shall not possess or consume alcohol or illegal drugs while on probation. At his probation officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work required by his officer, gain and maintain employment successfully throughout his probationary term, notify his probation officer within 48 hours of any change in his employment status, residence, telephone number, or email address. He shall have no contact with the co-defendant, which I believe is Victory Ogilvy. Defendant shall submit his DNA to the KBI data bank and be responsible for the $200 cost of the test. He shall abide by any curfew or travel restrictions imposed by his officer, follow all standard conditions of probation, not have in his possession firearms or dangerous weapons, and avoid disreputable characters and places. He shall also make monthly payments on his obligations in a manner acceptable to the court. Court will be assessing a felony docket fee, a felony probation fee, $200 DNA as announced earlier, $400 restitution to the KBI laboratory, $100 bids application fee, and $200 in legal fees. The court will waive the remainder given the size of some of the other cost assessments in the case. Court will require at least a $100 a month payment starting with the calendar month of June, Mr. Prince, and every month thereafter until paid in full. Further, Mr. Prince, I get the impression that you do not take this seriously.
No, I do.
I was insulted by your comment.
I've been writing everything
And
down.
I'm also insulted by the fact that someone.
Wait, he takes it seriously. He has a pad. There's it. He doesn't even have a full pad. He just has one piece of paper of the small 99-cent pad, the little one. So, taking it serious, Judge. Writing it all down. Get your commissary ready.
That's facing a felony sentencing, it shows up 30 minutes late for his sentencing. I accept your apology, but I don't think you take all of this very seriously.
I do, Your Honor. I take it very seriously. I'm here. I talk to Chris Pate. I show up. I show up to everything. I turn myself in. I'm on the Zoom calls every day.
Pate won't even look at him. Pate's like, you're screwed, dude.
I tried my best to get here on time, sir. I went and got a haircut.
They're all looking down. Look, all three of them are looking down. Shut up. Look, all looking down.
You can be quiet now. The court wishes to finish your sentence.
Shut up.
Court's going to order you as a condition of probation to the Greenwood County Jail at this time. Court's going to order the defendant to serve 96 consecutive hours in the Greenwood County Jail as a condition of probation. That should call for a Sunday release, Mr. Prince. Court will not grant credit for the 1 day previously served against this part. This is separate and independent. He does receive jail time credit for that 1 day, but not against this time imposed as a condition of probation. I hope that during the next 4 days, Mr. Prince, you really contemplate how serious this situation was and how important it is to keep your obligations to a court system on time. Apparently, you don't take seriously.
Shut up.
And quite frankly, Mr. Prince, this court was prepared to impose the maximum jail time, which would have been 60 days in your case, quite frankly. However, the court has reduced that in its actual sentence only because of your apologies that you've made today, which to a certain extent is more responsibility than you've ever taken before. The court is of the belief that a jail sanction is certainly appropriate given the defendant's conduct and involvement in this matter. All right. Court's already dealt with the issue of jail time credit. I won't revisit that. I'm not aware of any other restitution but the KBI laboratory, which I've already assessed. At some point in the future, Mr. Prince, you may have a right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to an attorney, and I'm sure to get your questions answered. Under some circumstances, you could have the right to appeal a conviction to an appellate court having jurisdiction. And if you are unable to pay the cost of an appeal, you, the defendant, may request the court to appoint a lawyer to represent you on appeal. and that you be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Morgan,
Yes, Your Honor.
I trust that you're going to be his assigned supervising officer.
That is correct.
Okay, he's obviously has to serve a jail sanction in the Greenwood County Jail. What direction do you give Mr. Prince regarding getting started with you?
I'll just contact the jail. There's some paperwork if we're going to move forward with the compact that needs to be signed as soon as possible. So I'll get with them to get paperwork signed and go from there.
I certainly encourage transfer of probation to his home county. I don't want him being around here and falling in with the wrong people again. So let's make sure he's supervised in the location that he's most likely to be successful. All right. Ms. Gillette, are you aware of any other sentencing related matters that the court still needs to address?
Did you say the right to appeal and expungement?
I did.
Okay.
Bravo.
I want to make sure that the record reflects all costs, however.
I don't-
$200 DNA, felony docket fee, felony probation fee, $400 KBI lab, $100 bids
He
application.
is the wrong people.
$200 attorney fees, and then the booking and fingerprint fee that would be standard for this case.
Did you say the supervision fee of 120?
I did.
Okay.
I don't know if I specified the amount, but I assessed a felony supervision fee.
That's about all I have, Judge. Thank you.
So Gillette wanted to go easy on him, but Party Rock, nope. Judge Ricky had other plans. Wow. Dude, show up on time. Really? Like, this is the most important thing you have to be on time for. And now he made a wrong turn at Albuquerque, as in my words of Grimm. Bravo, Lucy. Okay, are we ready? Brian versus Brian. The epic showdown. Well, it was pretty one-sided, but here we go. Let's do it. Let's get it going.
5860301.
All right, here we go. The only thing wrong with this video is that it didn't pan to her the entire time. Because if it did, probably a Bryant all-time classic.
All right, Miss Stevenson, what do you need to say from me?
Okay, Judge. So I think
you're
that took
dead.
a load of courage, and that Mr. Bryant did have.
And give it up for poor Miss Stevenson. Oh, she tries. Oh, she tries.
Just that quickly an epiphany as to what exactly is going on with the possibility of him losing his freedom for failure to comply with this court's order. And I'm not going to waste the court's time and get into, any back and forth about anything other than the fact that there may have been some confusion totally on Mr. Bryant's part with regard to what he should and should not have been doing about this case and during COVID. Judge, I am just asking the court to give Mr. Bryant the opportunity to come into compliance.
No,
I don't see how that would.
Interrupt you. No, he already told Miss McCall that he wasn't going to do it. Why would I give him a chance to do it? He was clear in his words and very rude and disrespectful in his language. It just seemed to me that anybody with half an ounce of decency wouldn't curse out the probation officer, let alone a man cursing out the female probation officer. It's just some stuff that's just rude and disrespectful on any level, let alone talking about being in court, let alone talking about someone calling you in their professional capacity, someone who didn't order him to do any of the things that he was ordered to do, yet Miss McCall had to be subject to rudeness and cursing and all of that. No, he is clear. And based upon what I read in the report, he maybe he feel like, you know, this little bit of something, you know, if he would have let us help him, maybe he wouldn't be facing these other charges. And of course, the other charges are charges, and I'm clear about that. Those other charges are charges, and he is innocent until proven guilty. And I am a staunch believer in that. But what I'm saying to you is, it's so rude and disrespectful. And if I was Miss McCall, I probably would have lost my job, because they would have heard me cursing back at him probably. No, they probably wouldn't have. They might have heard me saying some stuff at him, though, because this is rude and this is disrespectful and this is unnecessary. And Miss McCall, she didn't wake up in the morning, go to work and say, oh, let me call my probationers so they can curse me out. That's so disrespectful. Miss Stevenson.
Thank you, Judge. And instantly, I went all over that with Mr. Bryant when the court let me talk with him on the phone just a few minutes ago. And instantly, once the court made its position clear, instantly, Mr. Bryant adjusted his behavior. I make no excuses for the conversation that Mr. Bryant had with Ms. McCall. I believe it happened, and I don't make any excuses for it. But I do believe that the conditions of probation that have been set forth by this court could do nothing but benefit Mr. Bryant and this community if he were to take advantage of that. So I'm going to ask the court to give him an opportunity to do that. I think Mr. Bryant, he clearly understands, and he's demonstrated by his adjustment and his behavior what happens if he doesn't follow court orders.
Well,
and I think it's good that he came to court in person rather than, you know, having the cloak of Zoom, you know, to kind of protect him and kind of embolden him to do some things that he knows he should not be doing. But he has adjusted his behavior. He's changed his tune. He's acknowledged having talked with Ms. McCall. He did tell me that he didn't believe that he agreed to these terms and conditions of probation, but I did express to Mr. Bryant that was the sentence of the court, and so he really wasn't in a position to agree.
Oh, I guarantee
anything.
You, though, I guarantee you, if I have Mr. Flanagan pull the file, because this is when we were in person. This was before COVID. This is when they were signing to acknowledge the receipt of it. But I'm glad you explained to him that nobody asked him to agree to the terms and conditions. What would my job be if I needed the defendants to agree to the terms and conditions of the order? Then we would just ask the defendant, well, what do you want to do? We only need a secretary to write down what somebody say. We only need a secretary to type in what somebody say they want to do on probation. We don't need a judge who went to law school and practiced law. We don't need a judge if all we're going to do is have people agree to what they want to do.
So I think he's heard that, Your Honor. And I'm asking for an opportunity to comply with the order.
What? This is not his first rodeo. You saying he asking it. You saying, you acting like he new to this. He not new to this.
I'm acting like an advocate, and I'm asking the court, to give Mr. Bryant an opportunity to benefit from the conditions of probation, which this court did order.
Well,
he did come to court in person, Judge.
He had to. He thought he had to, Ms. Stevenson. Well, he didn't even have a Zoom ID number. Let me say this to you.
Everybody
6115 Seneca. 6115 Seneca. Well, if he didn't come in person, he wouldn't have come because he didn't even have a Zoom information. He thought he had to come in person because he looking at these other cases that he had and they were in person. Those cases were in person. So he was thinking he had to come in person. First of all, he shares my last name, which is an embarrassment. So let me just say that. Yep, it is. It is, because you done cursed out the probation officer. So that's in a minute.
Probably not.
So I'm letting you know it is an embarrassment. And I want everybody to know we're not related. We're not related in any way, shape, or form. Because the people related to me wouldn't be cursing out their probation officer. That's number one. Number two, he's not new to this, but it looks like he's true to this. Let me say that. He's not new to this. but it's certainly looking like he's true to this, true to coming to court, true to having cases, true to not following his probation. I don't know Mr. Bryant. Therefore, all I can do is look at his resume, and your resume sucks. So I don't know who he is. I don't know where he came from. I don't know what he's done in his life, but I'm looking at his resume. And it looks to me like the job he's applying for is the Michigan Department of Corrections. Prison.
Let's not hire him today, Judge. Today,
Well,
let's let him go ahead and try to make something good of his life.
I don't want to hire him today, but what I want him to do is stop being a statistic. What I want him to do is stop proving people correct who says that when Black young boys are born, that they're only going to end up in prison. What I want him to do is stop making those people correct. What I want him to do is act like that somebody in his lifetime told him to be respectful to a Black woman who has probably struggled her life, and now she got a job as a probation officer, and she's done nothing to Mr. Bryant to cause him to curse at her.
Completely true.
Why did I say 6115 Seneca? Because that's where I was raised at, the east side of Detroit. And this is some street stuff you doing right here. But what I want to say is I can go street too. When you get street, I can get street too. So your behavior has been deplorable. Your actions on this probation have been deplorable. And Mr. Bryant, if you want to prove the people right, who have discounted you, who don't think nothing about you, who expect this type of behavior from you, keep proving them right. Keep proving them right. But when people don't think anything of you, the best revenge for that is to prove them wrong. Now, I'll let you speak. You can speak.
Your Honor, I was in a dark place at that time, and I was totally wrong. If I could take my actions back, as far as that day in that conversation with the probation officer, I definitely would. Now, I'm a little sober now, well, a lot sober than I was then. I had some serious things happen. My wife got killed. I got shot 3 times. So I'm trying to get a lot of stuff behind, if that makes sense.
It does. Mr. Bryant, it does. And let me say this, I've never had a spouse to get shot. I've had some people die. I've had some people to die prematurely. I've had some people, but I never lashed out at somebody else. But we all handle stuff differently. So I appreciate the apology, and I'm sure Ms. McCall will too.
I was all the way wrong now, all the way.
All right. Well, I'm glad, because you see my 2 officers, they standing behind you. I can only see one half of one of them. Because I told them to get ready for the great door. Because I felt like you wanted to go to jail. You ain't want to do it. I felt like you ain't want to do it.
Your Honor, I just spent 60 days in the county this year.
Did you?
I don't want no more parts of the county.
And that's what I don't understand, why people do stuff to go back to. It was dirty, wasn't it?
That's an understatement.
I know it is. And the food was nasty. Did you eat for 60 days? Because I would have went on a fast.
Gotta eat to stay alive.
I know, but I would have been on a fast. Maybe I need to, because I need to lose about 20 pounds.
Too, at least.
Maybe, but I don't want to have to lose it in the jail, because I'm gonna lose more than 20 if I go in there. Listen, Mr. Bryant, I appreciate the apology. Let me double back and say this. I am so sorry for your loss. Now, I've meant everything I said this morning, but I'm so sorry for your loss. I'm sorry for your loss. I'm assuming your wife was at least your age or younger. And so I'm so sorry for your loss. I would not want anyone to experience that loss. And so I'm so sorry for your loss. But you got to learn how to redirect and not take. We're not responsible for what is occurring in your life. And in truth, if you give us an ounce of a chance, we are here to help you. I know that sounds crazy when you think about court, but you don't know me and I don't know you, even though we share the same last name. You don't know me and I don't know you. And you don't understand and realize, you know, what it is that we stand for in this courtroom and what it is that we're trying to do. And that's why when I get attacks and people talk about us and do different things, I understand it, because when you're trying to help people, a lot of people don't want people to be helped, which is the craziest thing to me. So, so I appreciate your contriteness. I appreciate the fact that you doubled back. I appreciate the fact that you did stand up. And then I did misunderstand your head shaking. And when I said I was gonna bring in Mr. Hunter, and then you were just trying to tell me you talked to a female, and you are correct, Ms. McCall. So my officers, they could stand down, because I told them get ready to put him in the back. Like, we ain't even playing. Get ready to put him in the back, because he want to go in the back. I was thinking you were saying, I want to go in the back. You're facing some stuff, Mr. Bryant. You are facing some things. You have some show causes coming up at 36th District Court. You owe a lot of money to the court, and you have a felony case pending with Judge Christopher Blount, who used to be my colleague on the 36th. So you got some stuff that you're dealing with. And if drinking is any part of it, or drinking or drugs, because this particular case is a drug case, you need to stop immediately, and you need to try to lean into this probation, because it may be able to help you be successful in the other things that you're facing. The tools that we're trying to send you to, I don't know what he was ordered to do. I'm looking for it. I'm trying to look for it on the register. But if I can get Mr. Bryant to Mr. Rice, I think we can do a world of difference. But let me see what he was ordered to do. I don't see the terms of his probation. I just see the money. Oh, here it say no illegal drugs, random outpatient treatment, mental health evaluation by this commissioner. So this is what I'm going to do. I want to amend his sentence. And instead of the 5 days of community service, I want him to do the choices program with Mr. Rice, or either choices or aggressive self-realization, whichever one Mr. Rice think is most appropriate. So I want to amend his sentence, and instead of 5 days of community service, I want him to see Mr. Rice. Now, Mr. Brian, you told Ms. McCall who gonna pay for it? Who gonna pay for the drug test, for the urinalysis test? You say who gonna pay for that? You ain't doing that. So let me say this to you, Mr. Bryant. I don't want you to go to jail or prison, neither one. But from this point forward, you should understand that it's basically your choice. Like, you're choosing where you want to go if you continue in your behavior. What I will do is I'm still ordering the drug test. I'm still ordering the urinalysis. But if you do it at the court, if you do it in the court's lab. Hold on, let me write this. Mr. Rice. Choices.
One more time, Your Honor. I'm working again, so if I have to pay something,
All right, so if you're working now, then you can start paying towards these. But if you come and if you do your drug test at the court, then I'll waive the fee for the drug test. But if you do it, if it's like more convenient for you to do it at one of the outside labs, I have no control over their fees and I can't waive them. But if you do it at the court, I'll waive the fee. And then you owe us on this probation $12.66. And then you need to try to get on a payment plan with your traffic balance. But when you see Judge Yancey, you know, you have a show cause with her, maybe she can do something with your traffic balance too.
He just went recently, Judge, and so he said some of that has been adjusted. I've suggested to Mr. Bryant that he stop downstairs in anticipation of this court giving him some mercy, that he go downstairs and get it.
One day I'm gonna prove you wrong. One day I'm gonna just let Mercy go out the door. One day I'm gonna prove her wrong. Well, I was gonna prove her wrong today if Mr.
Right, it was so close. Thank you,
real
Mr. Bryant.
It was
Shoot.
real close. But according to Ms. McCall's report, though, he has another upcoming on May 22nd.
Right.
So he has May 22nd and July 5th. I don't know why they gave him two separate ones, but when you go on May 22nd, ask them to pull all your tickets. There's no sense of you coming back to Judge Yancey twice. You have a court date, I'm sure it's on Zoom with Judge Yancey on May 22nd.
I know that.
Yeah. So Mr. Flanagan, maybe you could print him out the show cause. It's I could give you the case number, Mr. Flanagan.
Okay.
His case number is SP 1365652.
All right, I'll print it out.
And it says he has a show cause on May 22nd. I want to see Mr. Bryant in 2 months. I'm going to reinstate him. When you talk to Miss McCall, first thing you're going to do is apologize to her, okay?
No problem, y'all.
Yeah, apologize and tell her I was having a bad day and I'm sorry I took it on you. Can we just get started with this? And then she gonna say, yeah, but don't curse me out again. Okay, so probation reinstated. And I want to see Mr. Bryant in July. So let's see. I want to see him July 26th. Let's do July 26th at 10 o'clock.
And the other conditions, Your Honor,
Everything else stays the same. What?
Okay.
Let me see. He has to get back reinstated with testing. Well, it says at jams, but not at jams. They know not to send my people to jams until jams get their system together. But testing twice a month. It said NA twice a week and outpatient treatment. I will amend that to say, well, he just told me he was drinking. So I'm going to amend that. So Mr. Flanagan, you could also, I'm going to amend that to say any positive screens, then he has to go to NA and outpatient.
That's good. She's even giving him a chance with that.
And I mean, anybody know that he needs some type of grief counseling or something in losing his wife. So I do want him to at least, maybe do some grief counseling so it won't take him to drinking. But I think if he sees Mr. Rice is going to give him some tools to help him.
He knows she's helping him out.
Anything further? She going to give you instruction in anticipation of mercy. Isn't that something?
So he still has to do the mental health evaluation.
Great job.
Mr. Bryant, did you go to grief counseling?
No, ma'am.
I want him to go to grief counseling.
Okay.
So he doesn't have to do the mental health evaluation, but I want him to get some grief counseling. How long ago did your wife pass?
Year and a half ago.
How long ago did you get shot?
It was the same incident.
Okay. I want him to go to grief counseling. So
that was a good one. All right, guys, make sure to hit that like. We got Kitch coming up. I appreciate everything, guys. God bless you. Make sure you check out Kitchen Court Cases. Make sure you check out all those people on my page. They are awesome. They put in the hard work. And I hope you guys are enjoying my new format with the production. Put a lot of time in that. Thanks for all the comments. I appreciate everything. We have a good thing going, and this is yours just as much as it is mine. I appreciate you all. Never go to bed angry. God bless. Kiss your loved ones. See you tomorrow. You've been served.